So kia koutou, welcome. Thank you very much for coming to this bioethics seminar. This is another in our new series of seminars where we're taking topics that we think are particularly important and pressing and having comment from a number of different perspectives. My name's John McMillan. I'm particularly interested in the intersection of ethics, clinical practice, and law. So this is kind of a great topic for me in terms of my interests, and I'm delighted that Joe Manning and Lucille are able to join us for this seminar. So Lucille is a clinical director at Auckland DHB. She's an internal medicine specialist with specialties in general medicine and obstetrics. And the genesis of the session are some discussions that Lucille and I had a while ago, along with some other postgraduate students, about the Maharaj case. And it raises some pretty deep ethical and clinical questions, but also some, I'm delighted to see people like Ron Patterson and Alison here, because some kind of long-lived issues in the common law. So I'm delighted that Lucille is here, and we're going to be able to have her expert clinical input into this discussion. It was in discussions with Lucille, I think, who mentioned, maybe Jeannie actually, who told us that Joe Manning was writing a paper about this. Joe is an associate dean at the Faculty of Law in Auckland and a professor of law there. And if you look through her publications, she's someone, like some of the other people in the room actually, who have written about legal issues that are in-house law and pressing policy issues. So she's written about compensation and research, which some other people in the room have worked on, the HDC Code of Rights, and Ron Patterson's in the middle of my screen, so I'm thinking about his contribution to the topic too. And so it's kind of great to see the paper that she's written that talks about the Maharaj ECMO case, which is a withdrawal of treatment case. And Joe will start us off by talking about that. The second case that we'll talk about is, in some ways, a withdrawal of case, but a refusal of treatment case, and raises some questions about capacity. Now, the thing that led Lucille and I to thinking about all of this was, here are some difficult legal judgments that are occurring within the context of a healthcare system that is under extraordinary pressure. So sitting in the background of both of these judgments are significant resource constraints and treatment decisions that are very resource intensive. So I'm hoping the discussion will we'll get to some of those issues. So Joe, I'm going to have a go at sharing your slides now.
Okay, well, my role is to provide a brief outline by way of background to the common law up to the Maharaj case. And so I'm going to skip through this pretty quickly, because really we want to have some discussion around comparing Maharaj and the later case of Justice Lang in P. That's the really fascinating issue. So first of all, next slide, how does the common law, the criminal law, come to be involved in these cases? So doctors are concerned that when they withdraw life-prolonging treatment, which they might consider futile in the circumstances, they might be in breach of their legal duty in Section 151 of the Crimes Act to provide the necessaries of life, long held to include medical treatment, to a vulnerable adult in their care. Breach of this legal duty can make their conduct culpable homicide, and it can form the basis of the offence of manslaughter. So they wish to be sure that they're not going to be criminally culpable and that they would have a lawful excuse. There it is in Section 160, subsection 2B, the defence of lawful excuse. Should support be continued? So sometimes they've approached the courts for a declaration that what they propose to do will be lawful. So next slide. The first case to come before the courts was Justice Thomas in the Auckland Area Health Board case against Attorney General in 1992. And it concerned a man with extreme Guillain-Barré syndrome who had been placed on a ventilator when the nerves in his chest could no longer function unaided. It was thought that there was no prospect of recovery for him, and his doctors wanted to withdraw the ventilator. His wife agreed, but they were concerned that if they did so, they might be prosecuted for murder or manslaughter. So they come to court seeking a declaration that it wouldn't be unlawful to take him off the ventilator. Justice Thomas held that the doctors would be legally justified. They would have a lawful excuse in withdrawing life-prolonging treatment in terms of Section 151 if discontinuation accorded with good medical practice or some such equivalent phrase. And there's the quote on the screen. See, next slide, thanks, John. Justice Thomas gave content to that phrase, good medical practice, and the criteria were summarised in the later case of Shortland, and there they are on the slide. They comprise a bona fide decision by the attending doctors that withdrawal of life support is in the patient's best interest. So that's the ethical basis, best interest decision. Compliance with medical standards and practice, so relevant tests and consultation with other consultants. So a general consensus that withdrawal of treatment is in the patient's best interest. Approval by the profession's recognised ethical body, and fully informed consent of the family or guardian. So next slide. So Auckland Area Health Board contemplated a joint family and medical decision, the basis of which was a best interest decision. But there would be other input, such as consultation among doctors and ethics committee oversight. Justice Thomas considered that if these criteria were met, then doctors would not have to come to court. These would operate as procedural guidelines. They could reach and administer these decisions without recourse to the court. But the implication was that if the criteria couldn't be met, if family didn't agree, ethics committee approval wasn't there, there was no medical consensus, for example, then there should be recourse to the court for approval. Auckland Area Health Board caused anxieties in the profession in that it purported to give the family a veto over withdrawal of life-sustaining treatment. So if the family could refuse consent and thereby prevent doctors doing so, this could have the unfortunate consequence of obstructing doctors in allocating expensive life-prolonging health treatments fairly as between patients, all of whom could derive some benefit from the treatment. And this indeed would be unfortunate, and most would shrink from a legal principle that permitted naturally partial families divorced from the harsh realities of limited resources and the knock-on effect on other patients to dictate the use of scarce resources. Next slide, thanks. So the next case is Shortland, and it remains, as a Court of Appeal case, the leading authority in this area. You'll remember that it concerned Mr. Roe Williams, a 63-year-old Maori man being treated for end-stage renal failure with dialysis treatment in Whangarei Hospital. His doctors sought to discontinue treatment because he fell outside priority setting guidelines which had been developed to assist providers decide the priorities as between patients for access to this scarce resource. There had been no approval sought from an ethics committee, and Mr. Williams whānau didn't agree to the cessation of dialysis, and they came to court seeking a judicial review of Northland Health's decision. You'll remember perhaps the furore surrounding this case, and because of the public suspicion that the real reason Mr. Rowe Williams was not being provided with dialysis treatment was a resource allocation decision, arguably a defensible one. But the Court of Appeal accepted the hospital's assurance that there was no resource dimension in the case. The decision was, the court said, par excellence, a clinical judgment as to what was in Mr. Williams' best interests. So this decision has been regarded as relevant to best interest cases. So next slide. Thanks, John. So faced with non-compliance with two of the criteria of Auckland Area Health Board, the court watered them down. The criteria, it said, weren't necessarily applicable in their entirety in every case. Even though the third and fourth weren't met, the decision to withdraw treatment was not unlawful in this case. Consultation with an ethics committee wasn't required because priority setting guidelines were applied, which had themselves received ethical input. And the fully informed consent of the family wasn't obligatory in all cases, because that would give the family the power to dictate to doctors what was in the best interests of the patient, and the law could not countenance such a general proposition. So the family have a right to, where circumstances permit, reasonable consultation with the patient, and such members of the family are available. Next slide. So Shortland moves the law to a medical-led model based upon a medical best interest judgment with family consultation. Those two second and third criteria of Auckland Area Health Board are not applicable in every case. And there was great deference to the medical profession shown in Shortland. It's not for the courts to be arbiters of the merits in cases of this kind. It was unclear whether it was necessary to come to court for approval when the Auckland Area Health Board weren't met, but it seemed that Shortland later was read as saying you don't have to if the criteria aren't fulfilled. It wasn't read more narrowly as saying if the criteria aren't fulfilled, it may not be unlawful to withdraw consent, but you'll need court approval. So that brings us to the Maharaj case. Next slide. This concerned a man aged 46 years who's admitted to the intensive care unit at Auckland Hospital in July 2023 after a heart attack, which had resulted in the rare but lethal complication of a hole having been torn in the wall dividing the chambers of his heart. Because of his relative youth, he was placed on an ECMO form of respiratory support, usually used as a last resort and only if the patient has a survivable condition. The plan was that he would be assessed to see if there were any options for treatment. And over the next fortnight, he was assessed by 3 cardiologists and 2 cardiac surgeons, and they concluded that there were no medical or surgical options available to repair the hole. It was too big. There was no way that it could be closed. There was no reasonable possibility of him recovering, and accordingly there was no benefit to him remaining on ECMO, and life support should be withdrawn. Next slide. So there'd been no approval by an ethics committee, and most importantly, the family disagreed, and they were given 24 hours before ECMO would be withdrawn, and so they were told that they should approach the court for an interim injunction. and they did so. They wanted to prevent life support being discontinued for 5 days to enable them a reasonable opportunity to seek second opinions from overseas as to whether his case was indeed hopeless, and also to permit them to carry out religious rites in respect of their relative. We aren't told what his religious values were, but the family wished to perform religious duties in respect of him. Justice Eaton gives an oral judgment, rather unfortunately in my view, as to the lack of ethics committee approval. His Honour accepted the hospital's argument that ethics consideration and approval isn't required where there's no alternative medical interventional option available, and hence there's no ethical dilemma for an ethics committee to resolve. I'll leave that for others to comment on. Neither did the lack of family consent render the proposed withdrawal unlawful, and Shortland was applied for the principle that the family can't be given the power to dictate to doctors a course of treatment contrary to their clinical judgment. There was also a suggestion here that the family were in shock and that there had been various factual misunderstandings, and as a result of which their disagreement wasn't informed. Unlike previous cases, the hospital argued that removal of life support was a legally justified resource allocation decision. Without much in the way of evidence to support the assertion of risks to other patients, that was taken as not having to be proved. Judicial notice could be taken of that. And no law was cited. The judge was satisfied that the lives of other patients who might otherwise survive heart attacks would be lost if Mr. Maharaj is to remain on ECMO. This is the harsh reality of a limited resource. And so he accepted an allocation decision as a relevant additional defence. There was no evidence, so next slide I think it is, no evidence, no consideration about any wishes or statements Mr. Maharaj might have made in the past as to what he might want to happen in these circumstances. No discussion of his beliefs and values, what, for example, were his religious values, any matters that might influence his decision if he had capacity. Apparently he had a disabled son to whom he was very close. So the decision is very much a contest between the doctors and the family. Justice Eaton doesn't himself consider Mr. Maharaj's best interests and conclude as to where they lie. Rather, he shows deference to and delegates the decision to the medical profession. In the previous slide, there were quotes to that effect. In the UK, so here's the section 4, 6 and 7, section 4, subsection 6 and 7 of the Mental Capacity Act 2005, which is the so-called best interest checklist. So the decision maker as to best interests is required to consider the person's past and present wishes and feelings, in particular any written statement they may have made, their beliefs and values, and any other factors he would be likely to consider. Must also take into account the views of anyone engaged in caring for the person or interested in their welfare in a particular way as to what would be in the person's best interest, and in particular as to the matters mentioned in subsection 6. In other words, what the person might want to happen in the circumstances. And the Court of Protection cases, next slide, has been profoundly influenced also by Baroness Hale's statement in the Aintree case in the Supreme Court about the need to look at matters from the person's perspective and attach significant weight to evidence of an incapacitated patient's wishes and feelings. She said the best interest test should contain the preferences of the person concerned. These are an important component of where his best interests lie. It's not a substituted interest test, but the best interest test should contain a strong element of substituted judgment, she said. Okay, so that's where we are. The last slide, I think, just gives a summary of where we are in New Zealand. Good medical practice with its 4 criteria. The Ethics Committee approval and family agreement not required in every case. The patient's wishes and feelings and values are a relevant factor for their best interests, but there's no real case law, but more recent case law, but not in Maharaj, to suggest that they're no more important than any other factor. Okay, that's me. That was a race through.
Great, thank you very much, Joe. I was really, really impressed by how you managed to cover most of the common law leading up to this and the key details of this case. Joe's written a fantastic paper that lays all of this out. So if you want to go back and read through any of these points, you can. It's in the New Zealand Law Journal. I thought that I might hand over to Lucille now to see what thoughts she has about the Maharaj judgment and where that leaves us clinically.
No, thanks very much. And gosh, thanks, Joe, for that great summary. So I'm a physician who works outside of an ICU, but I work alongside our ICU colleagues. And I think the key thing in this case is that the intervention from the beginning was probably futile, but it's really hard to make that decision in a setting where you've got that intervention available, which is only at Auckland Hospital, of course, in New Zealand. Any other hospital in New Zealand, Mr. Maharaj wouldn't have made it past the emergency department. So it was an extraordinary thing to do, but once you've done it, it's really hard to backtrack on that. And then clearly there's been a background, a breakdown in communication and then in the relationship with the family. And this happens. And these situations and conversations happen every day in ICUs throughout New Zealand. It's really distressing for everyone involved when the family and the medical team end up disagreeing on the way forward, and that involves a lot of meetings and a lot of time spent and a lot of support. In this case, it's super distressing to have a family forced to go to court to advocate for their loved one, and I think all of us can feel for them. I think it's always difficult from the outside to sort of understand why time would not be given to obtain an outside opinion. But I do have to concede that even if an outside opinion was obtained, it is highly unlikely that any alternative treatment option could have been offered in the setting that Mr. Maharaj was in, and he would not have been able to be transported to another country because of both his clinical case and the many hundreds of thousands of dollars that is required to transport someone in that state. So you've got a very distressed family, and you've got probably an equally distressed clinical staff, and then we end up in court. Not ideal, doesn't happen very often. Usually people won't have to end up in this situation. But the thing I think the Maharaj case has done for people thinking about this clinically is a concern about its application to cases that don't meet these clinical facts. And a little bit like Shortland, will we see an extension of this decision into other areas? And I agree with you, Joe, a real concern about the best interests discussion and taking into account what that person might have wanted or not wanted, and the family's advocacy for the patient. And also, I suppose the thing that I worry about, and I talk to my colleagues about when they ring me about these decisions, is, the requirements of the HDC Act, and at what point do resource limitations override these rights, particularly with communication, having access to a second opinion, and how much time and resource should the healthcare provider have to put into meeting these requirements, and how much sits with the people who don't agree with the decision. So those are the thoughts I've had about the case. And yeah, I'd really love to hear what other people have to say.
Thank you, Lucille. Just on that that important point that you've made about what this might mean in terms of a precedent and how it might go in clinical practice, I thought I might pass back to Joe. I saw you nod your head at that point. Did you have thoughts you might share on that? You're muted at the moment.
That was really interesting. What would I say? This is the first case that I've seen where the family was really railroaded. They were given 24 hours. And in terms of allocation of resources, most of the cases overseas, some of the Australian cases, you've seen the hospital facilitate a second opinions, because it can be hard for families to get them. And also just give them some time as part of the grieving process, so that they hear from somebody overseas who says, look, you can rely on these clinicians in Auckland. They're making a decision we would make. It's correct. And I think if people are treated with dignity in that way and given enough time to get second opinions, the family said in this case, if the second opinions were the same as those of the treating doctors, then the dispute would resolve. And I've seen up to 3 or 4 weeks given. I'm not suggesting that's a good idea, but in some of the cases overseas, to let the family get there, if you like. I'm not advocating that, because yeah, there is a resource allocation, there's a use of expensive resources here, but I just think 24 hours, that's just wasn't helpful.
So, Joe, one of the things that struck me on rereading the judgment was that the Te Whata Ora advised the family to seek a court order. So it ended up going to court because something had happened, and you would kind of hope at that stage there'd be something that would bring the family on board with what was happening. One of the things
courts in New Zealand have been the decision makers of last resort, and that's another question. Should these decisions actually be made by a court? They're not legal decisions. They're ethical in nature, about length and quality of life. It's an evaluation of somebody's best interests, hopefully taking into account their own views. Is there a less formal way, ethics committee, that sort of thing, of doing this? So, but that's a whole nother question. Yeah.
So the question around the assessment of best interest in the checklist and what that means in terms of ethics is one area, but there's also those of us who think about ethics would like to see decision-making under conditions of resource scarcity as an ethical question. And that the court seems to have sidestepped that both in Shortland and in this judgment, which is a troubling thing. There's another issue I want to flag here, and I'd be interested to see what Lucille and Joe think about this, was that the role of expert testimony in the ECMO judgment, it seems like the judge, everything that came from the clinicians was taken without question, and there are different views about. So at the moment, there's one specialist centre for ECMO in New Zealand, that's in Auckland. Not long after this judgment, I had a discussion with an intensivist at Dunedin Hospital, who said, "Oh, if that happened here, we would treat him and put him on. We would treat him and put him on ECMO." So the other interprofessional workforce issue is that there are people, specialists across the country, who want to be able to provide this as well. And I didn't think there was any interrogation or any questioning of the testimony by the judge, and there could have been.
That's a really fascinating point, John. I hadn't appreciated that. I remember David Collins telling me that in Shortland, a similar thing happened to him. He spoke to somebody from another centre who said, well, if Mr. Rowe Williams had been in our centre, he would have been treated with dialysis, you know. And the second criteria of Justice Thomas's Auckland Area Health Board good practice approach is kind of triangulation, seeking outside consultation with relevant specialists in other centres and overseas, so that you've got some idea that you can't get a unanimous agreement, but some idea that there is a consensus here as to the way the person, it's suggested that they be treated. And that didn't happen, and the family had suspicion around that and suggested that the Auckland doctors weren't truly independent. That there was pushback against that suggestion, and the judge said the fact that they're all in agreement suggests that it's not a difficult case, not that they're not truly independent. But in terms of just communicating with the family, you know, that's why they want an overseas opinion, just so that they can satisfy themselves that this is indeed an appropriate way to proceed.
But thank you. Lucy, I'm going to pass to you on this question of professional consensus.
Oh, look, it's a tricky one, isn't it, John? I could get myself in trouble here. I think it is always very difficult for a family, and I've had families in this situation where they have really strong belief that the medical profession are forming almost a cartel environment and saying, well, we're going to have a singular message and we're going to be saying this and no one can disagree with what we're saying. And I don't think that really happens a lot. I think the key concern here is how you seek a second opinion. And I think that has been raised, and I am concerned that we need to assist people to seek a second opinion so that they can seek it from an appropriate source, so not someone who doesn't actually look after patients in that circumstance, which is really important. And secondarily, can understand the resource limitations of the centre where the patient is. So there's really no point in seeking a second opinion, say, for example, from America, in a setting where if you have enough money, you can have as much resource as you want. That would be inappropriate. So I think those two things, we should be helping people to do this and doing it together. But that's really difficult if there's mistrust and the relationship is broken down. So I suspect that's what happened in this case, that they weren't able to do that. I've certainly done that with patients before, and families before, and been able to set up a process where they feel they've got a reasonable opinion that applies to the situation the patient is in and the setting they're in as well, which is really important. I don't know, Ron, have you got anything to say?
So look, thanks, Joe, for wonderful presentation, and Lucille. I mean, it just triggers so many thoughts. We now have a national organisation, Te Whata Ora. How can it be the case that you can have, although of course it is the case, that you can have different approaches? And this is something I saw as my time in Commissioner. When no neurosurgery, we would never excise in the situation. Then Grant de Klerk said, well, we would do it all the time. Here at Dunedin. So I think there's that issue. I'm interested, Lucille, in the language of breakdown in communication. I mean, it is an impasse in communication. It sometimes has that sort of flavour of, well, they're not going along with, the clear path that like it's not a breakdown as far as they're concerned. And so, I just have a slight question mark about that. I'm not with Joe I don't know whether Joe's seriously suggesting this in terms of thinking about some other process in terms of ethics committees. The fact that one High Court judge, I mean, I think it's lamentable that this judge, he's just letting down our legal system to issue a judgment of that quality and to do it as an oral judgment. But that doesn't mean that we should abandon the use in extreme cases of the courts as the most important protection of these human rights. And I guess we have to wait for a case that goes on to the Court of Appeal. Having said that, Joe and I wrote many years ago about the Auckland case. I mean, just the nonsense to pretend that there were no ethical considerations involved. And one other point just to make is, which I wrote about back in the 90s, at Ted Thomas's case, that in that very first case, the Guillain-Barré man, there was no reference whatsoever to what the man might have wanted. And whereas that factor is, I don't have all the names of the cases at my fingertips like Joe does these days, but the Baroness Hale, in the way in which the English courts and indeed the New Zealand Code of Rights incorporate having regard to what the patient might have wanted, which of course is important in a context like this for the reason it's possible that there might be evidence of effectively an advance directive that they wouldn't have wanted the treatment anyway, and so surely that should be considered. Anyway, enough from me.
Thanks, Ron. I'm aware that Catherine Hall, you were going to make a point too, and we might have time for a couple more before we go into the next case as well. Hi, Catherine.
Kia ora, everybody. Yeah, I actually looked after the Guillain-Barré case when I was in Auckland working as the ICU registrar. I actually looked after him for the majority of his case. Ron, I can't help you about the discussion of what happened when he first came in, because he came in on the night shift and I was a day shift. So he was already intubated and ventilated when I arrived, and it would have been done with the best of intentions on the basis that most Guillain-Barré cases are actually reversible, the vast majority. So at that stage, it would have been thought of as life-saving, preserving treatment, and therefore to be initiated, unless the person had some very strong wishes not to, and it would be a very, very difficult situation then, but very abnormal. So I assume he did consent on the basis that he would have been informed, yes, it is very likely we will be able to save you from this. So, but it's a bit of surmise. What I just wanted to give some context was that from my years in ICU, which amounted to about 5 years in various different units, the Auckland unit, unless things have radically altered, was by far in Australasia, and possibly in the Southern Hemisphere, the busiest ICU unit in Australia and New Zealand, by far. And they had to very carefully manage their resources. They had the poorest ICU bed to other non-ICU bed ratios, and the pressure on the beds would be enormous, vastly different from the other units I worked in, vastly different from Dunedin. There was, because of this sheer limitation of resources, huge time pressure to either people would fly or die, was the phrase, in the sort of humor of working in that environment. So it's just to give some context to these decisions and decision making. It's it felt like working in a battleground for a year. We had, just to put it in context, we had 15 beds and about, I think it was 2,700 admissions in that year. I could go and finish at 7 o'clock in the evening, be back at 8 in the morning, and find half the patients had changed overnight because of the pressure of beds. Huge decisions were made in the middle of the night that you could debate for days, but that would be made swiftly on the basis that someone else needed the bed, they had a better chance, the other person would be given a rapid wean off a ventilator, a tracheostomy, and they'd head off to another ward and they would not be readmitted, and that was their chance.
So thanks, Catherine. Tony's just put a link around that talks about the number of ICU beds per 100,000 population in New Zealand and Australia. And if you look at the US, the difference is even more profound. So we're talking about an ICU unit under extreme pressure, and the claims about scarcity of ECMO and worries about impact upon other patients. There's reasons for giving weight to those, and also kind of imagining how it's possible for breakdowns in communication to occur, which it clearly has in this case. We've got another judgment to talk about, so I'm going to move ahead and try and do this one quickly. In a way, this is a refusal of treatment case, but it also has aspects of withdrawal as well. Simon Lee has written a book where he talks about uneasy ethics, and he's got this nice quote, and he's referring here to Rie conjoined twins, which is a case involved surgical separation of conjoined twins with the knowledge that one of the twins would die on the operating theatre. And what he said is, this is not just a hard case, but an uneasy one, because the moral issues moving beneath it are so acute that if you don't have some sense of unease, you haven't understood the complexities involved. And I have that kind of sense of unease about some of the cases that we're thinking about now and the context in which they're happening, which is a healthcare system under significant pressure. So what I'm going to do is just quote some passages from the judgment, and then we can open the discussion up. Quite a recent case. Lucille sent this to me. Thank you, Lucille, and for circulating that. So some central facts. P, at the time of the judgment, was 26. She'd spent large portions of the last 7 years in hospital for treatment of a variety of health issues. The Triple PR Act is the mechanism whereby people can seek orders for treatment when somebody lacks capacity. And this judgment was about Te Whata Ora seeking an order to maintain adequate nutrition and safeguard her care, welfare, and all necessary interventions and treatments to preserve her life. P is opposing the order. She doesn't want any treatment being administered against her will. She now wishes to let nature take its course, even if that ultimately results in her death. P has had quite a long history of significant involvement with health services, so the concerns or problems with nutritional intake have been going on for at least 10 years. She and her parents believe that she suffers from untreatable gastroparesis, which I googled, and I think is something where your stomach doesn't move things through at appropriate speed, something along those lines. And they have requested palliative care since 2018. But there's no medical evidence that P suffers from a terminal or non-treatable illness. P and her parents don't accept that there is a psychological or psychiatric component to her clinical condition. The core diagnosis from the psychiatrist who have been engaging with P is that she has a factitious disorder, so a mental health condition in which she consciously self-induces, feigns, or exaggerates physical or psychiatric symptoms for the purpose of receiving care and attention in a medical setting. The testimony that was presented said that the disorder affects her insight and decision-making and compromises her decisions with respect to treatment and self-care. At the point that the judgment of the hearing, P was in a kind of very bad way. So she had a room to herself. The curtains are drawn because the light hurts her eyes. She's declined to be bathed. And apart from family visits on the weekend, she's isolated. She's very emaciated and too frail to have physiotherapy, totally bedbound, and does not partake of any exercise. She said that long-term residence in the hospital was not for her a life, and has consented to the administration of pain relief and treatment to control nausea using her nasal tubes, but hasn't been fed by tubes since her return to hospital at the end of last year, and is only able to eat foods such as mashed potato, which makes her ill. Completely dependent upon others. Every week she can't push her body up in bed, and she doesn't want to be under the control of other people, doesn't want to undergo any further surgical interventions to clean her wounds, and there have been a number of those since her admission, and wants to let nature take its course. So in the judgment, it refers to the Triple PR Act. It talks about Section 10 orders, and says that it's only in a situation where someone lacks wholly or partly the capacity to understand the nature, to foresee the consequences of decisions or matters related to his or her personal care and welfare, where this order might kick into force. 26 talks about what would have been forefront in the judge's mind when thinking about that. So Alison, I've heard talk about this in the past, as the PPPR Act is being revised. It has good bones, and two of the things that are in there which are prescient are this thought about orders enacting the least restrictive intervention possible in the life of the person, and to enable or encourage that person to exercise and develop such capacity as he or she has to the greatest extent possible. In 2018, which was when an order was made under the PPPR Act, there was expert opinion from two doctors here who expressed a concern about her ability to think about the long-term consequences of decisions. So Dr. Kennedy says, I think she's impaired around her ability to understand the nature and consequences of her situation. Dr. Syndrome said that in relation to omitting care in the longer term, he had concerns about her decision-making capacity. And in this judgment back in 2018, Justice Goodwin concluded, this is kind of interesting, remains a young lady who does not appreciate her situation and its consequences, and that she does not foresee the consequences of those decisions with regard to medical care. Now, the common law and statutes talk about the importance of having abilities and not exercising. And I thought this is kind of interesting slippage into assessing the actual appreciation that she has in the situation. Following that assessment, a number of orders followed, which are now being revisited in 2025, and there's a new assessment of her capacity. The three health professionals that met her thought that she had the ability to understand the decisions she's currently making about her healthcare and the consequences of those decisions. So she can make specific decisions about particular medical interventions. But all three of them were concerned, or were not convinced, about whether she had the capacity to fully understand the nature of the underlying affliction that has resulted in her requiring medical treatment. They each place significance on P's determination to receive palliative and end-of-life care rather than seek treatment for her factitious disorder diagnosis. Now, one of the things that jumped out at me when I was reading this judgment was that Justice Lang cites NZHC and JT, which are kind of older English cases, and ones where people had, in the case of C, a mental illness, and there was an assessment of capacity and a finding that this person had capacity, and goes on to reason that because she's consistently confirmed that she's making decisions that may result in her death, and that she knows that treatment and nutrition could keep her alive, she grasps the gravity of the consequences that her decisions may produce. Now, it's very similar to what was said in Ray C, which itself is a kind of interesting and perhaps slightly tricky judgment. Health professionals agree that she has the necessary capacity to validly accept or decline particular forms of treatment. She understands why the treatment's being offered, what it entails, the likely consequences of receiving or not receiving it. I see no logical distinction in this context between her capacity to give or consent to a single procedure and a series of separate procedures, which is kind of an interesting line of reasoning we might burrow into. He concluded that when these factors are taken into account, I do not consider the disorders for which P suffers have removed, either wholly or in part, her capacity to make decisions regarding the nutritional and medical treatment she's likely to be offered. I therefore consider she still possesses the capacity to make her own decisions. So the thing that jumps out is me, you've got three expert opinions, judges taken them on board and gone down a different track. So the order wasn't made. Now, Lucille directed my attention towards this judgment. I thought I might invite Lucille to comment and then to Joe, and then we can open it up to the audience.
Gosh, yeah, no, thanks. Thanks very much, John. I mean, this judgment was really concerning. I only found it, the way you find judgments. There was an article in the New Zealand Herald, which is how you find out something's happened. This is a troubling case for me and for clinicians who work in a specific area of looking after young women who are not eating enough food. And it's something I've done for a lot of my career. it's a concern because there's a large group of young women in this situation in New Zealand. And the key clinical aspects of interest to me are that this woman was very clearly in a very severely starved and malnourished state. And the argument then arises that, does this affect your cognition and competency? And if you're in a severely starved and malnourished state, would you have a different decision-making process if you were refed? And clinical experience amongst people who look after people in this situation is that, yes, you do. That people's decision-making changes substantially when they have better nutrition. And that's been shown in some studies. It's very hard. We can't have controlled studies because you can't formally starve people, although they did do that during the Second World War to a group of conscientious objectors in the United States. They starved them intentionally and did prove that, in fact, you became very incompetent with decision making when you were starved, and that competence was regained when you fed people. So, you know, we wouldn't be allowed to do that now, clearly. And so, you know, Miss Repe's case is really concerning because we didn't return her to a state of nutritional well-being that I would consider to be appropriate for making decisions. And there is a small part of the decision where they talk about when they have been able to take really intensive therapy for her with regards to medical treatments, keep her safe from infections, get her refed, that she in fact left hospital and had a period of time where her quality of life was better. And that troubles me. So I think that's the key thing that troubles me about this decision, is that this was all happening when she was very unwell. Clearly she's self-harming. The reason for the self-harm is of interest, and starvation in itself is a form of self-harm. And the problem we have is then when you have no clinical evidence of organic disease, is this primarily a psychiatric disorder or a behavioural disorder, and how do you then look at competency? So I struggle in this space. I struggle in this space clinically, but this decision does create problems for clinicians working in this area, substantial problems now. And I think one of the key things that came out also was that there was a very clear statement that you didn't have to agree with the diagnosis to be competent. I think I don't have too much trouble with that, but I have some issues with it. Depends on the extent of that, because if someone has a very intense belief that they can't eat because their stomach doesn't work, there is no organic evidence of that, when does that become part of assessing the competency to make decisions around that condition and treating it? So I struggle in that space. And when does self-harm, including starvation, move into the realms of committing a very slow form of suicide, and where does that come into with our duties as medical practitioners to protect people from dying from self-harm? So all these things are a real struggle for us. But the biggest concern I have, I think, is what does this mean for treating other people in this situation where we have, basically used Right 7.4 of the Code of Rights to treat people, to protect them from harm, and fed people in those circumstances. Palliation of a young person who does not have organic disease, how do the staff deal with that ethically and morally? A sense of letting someone starve themselves to death. These are all really difficult things for the clinical staff. How are we going to support staff in that circumstance? And the other thing I've raised with my colleagues, and we found this interesting, especially amongst the geriatricians, is that how would we consider this differently if the patient wasn't of this age? Mm-hmm. So if this was an older person who was saying, I just don't want to eat anymore, I've had enough of all this, would we let them do that? Or would we actually intervene and not give them their rights? I think age is a really important part of this case. I'm really keen to hear what people say. I think people need to understand this is an increasingly common scenario in New Zealand, particularly post-COVID. We've seen a significant number of young people who are not eating, and it's troubling. I see probably 2 a week, and I work in Northland. So this is big deal.
Yeah, thank you, Lucille. And also, the judgment talks about the hundreds of days that she's been in hospital. So these system capacity issues are forefront too.
Oh,
Joe?
yeah. So just to move on that, John, yes, I mean, the effects of the staff on looking after this woman long term are huge. And yes, then people do start to talk about, is this futile? And it affects people's decision making, and you should swap staff out. I mean, I have no doubt that you shouldn't have people looking after someone continuously for months and months on end, because their judgment will get coloured by fatigue.
Joe,
Well, I've got some I've got mixed feelings about this judgment, and I'm still thinking about it. So I'm very interested to hear what Lucille has had to say. There's case law in Britain, and a recent case in 2004 by the English Court of Appeal, which discusses the whole question of the link between somebody's not believing the medical information about their diagnosis and treatment and their capacity. And the English case, which is called Hemachandran against Thumu Alesh in 2024, says, where there is objectively verifiable medical consensus as to the consequences of not having or having medical treatment, if the patient does not believe or accept that information to be true, it may be that they're unable to understand and or use and weigh the information in question. So it's not determinative if you don't believe the medical information, but it's a red flag. It may be that you can't understand the information and you can't use it and weigh it logically to reach a decision. I think she was on that side of the line. I don't agree that she was competent. I think this is a case where, because she did not believe that she suffered from a psychiatric condition, so she didn't see the need, therefore, for psychotherapy, because she considered it useless to the physical condition which she suffered from. And because she believed that physical condition was terminal and not treatable, she didn't consider that nutrition through her nasal tubes was a valid treatment for the condition she thought she suffered from. So she placed no weight on the medical information she was given. She was not able to use that information and weigh it in the balance. This wasn't somebody making an unwise decision or a decision based upon a set of values different to the clinicians and the court. This was, I think, somebody who was not competent to decide because she didn't believe the medical information, and it prevented her from making and she had inability to make a decision.
Thanks, Joe. It's interesting you pick up on that, because one of the things that has fallen out of the English test of capacity is the ability to believe that information, which is in fact an insight test, which was part of the C judgment. And that seems key to the medical testimony in this case.
All the cases concerning anorexic patients have said that those patients are not competent to decide, and they all go off on a consideration of the patient's best interests. You suggested an interesting case. Mr. C thought that he was an internationally renowned surgeon who'd never lost a patient. So I reckon, while the test might have been appropriate, it wasn't properly applied. He couldn't properly weigh the chances that he might die from his gangrenous foot, because he thought that God didn't want him to die and that he had enough medical expertise to ensure that he wouldn't die.
Yeah, very, very interesting. So Alison has a question, and then Martin, and
yeah, but I don't know if
we don't have much time, but can we go on for a couple of minutes?
Yep.
Just
Just very briefly, I want to really just comment, just to say thanks so much, Joe and Lucille. Fantastic topic, very topical. And what it raises for me is that both cases are symptomatic of a lack of process around, both withdrawal of treatment and refusal of treatment cases in New Zealand. The driver in the UK goes back to 1990, Ray F., the House of Lords. Doctors are sued in the UK, and it's about the lawfulness of their treatment. We don't have that setting here. And as a consequence, we haven't developed the case law and the use of the High Court. It's an inaccessible process. And I think really what we need to be thinking about, and so we have no development of the terms, best interests, which is scattered across our medical and health law. And that is an issue that we need to look at and really be pushing for the reform, at the very least, of the Triple PR Act and what the Law Commission is doing. But I'm not confident that the Law Commission will be looking at the interface, essentially, with the HDC code and this broader area. So what can we do? I think there's also an issue around ethics committees. I was on a clinical ethics advisory committee, CAG as they were called, that went, to the Wellington High Court and gave an opinion, as some of you have done. So I think there should be a push with Te Whata Ora to have a recognition of the role of clinical ethics advisory groups and put in some process, because the High Court isn't really at where we're at in New Zealand. There are no drivers. And just finally, there is in the UK also serious medical treatment cases. There are guidelines that have been updated, which is the basis, and they are trying to limit in that jurisdiction how often they go to the court. So that's a whole development that we don't have around these kinds of cases, and when you don't need to go to court. So I think, in this seminar in the ethics community, we've got a real role. I mean, if we're not going to get the law change, at the very least, there would be a role in developing, guidelines and a process that would give some consistency around the approach taken.
Thanks, Alison. We can go over time
Yeah.
slightly for this one.
Yeah.
So Martin next, and then Josie. Anybody else in the room?
Look, it's all tremendously interesting, and I agree with everything. Everyone's doubts that P is competent. So just one puzzle about this case is why she's been both diagnosed with a factitious disorder at the same time as the judge accepts that she genuinely believes that she's terminally ill. I mean, the classic factitious disorder is somebody who knows they're not ill, they're just fabricating symptoms. So I don't know why, and perhaps you can explain this, why the judge just accepted without any demur the diagnosis of factitious disorder, and accepted without demur that she genuinely accepted the belief she was terminally ill. I don't see how it can be both.
Thanks, Martin. So I think these questions around how expert testimony is kind of evaluated in these judges are really on point. Lucille and Joe, did you have a comment on that?
All I can say is that I from talking to the people who looked after the patient, and it's been really difficult, a series of people, but I think you can look back at the original decisions prior to this decision for her court orders, and the my colleague Chris Kennedy, who is a very, very good dual qualified medical specialist and psychiatrist, felt exactly the same as you, that her situation didn't allow for her to have competency in the decision making, if you believed the diagnosis. And that is a difficult thing, because someone's put in the comments, what if the doctors are wrong? And I think this is really where we get into a dilemma, and increasingly getting into a dilemma with some groups of patients where there's an absolute mistrust of the diagnostic process in the medical system, and that there is an ongoing, increasingly support via the internet of an idea that the doctors have got it wrong, they just don't understand you, and therefore, you are dying of a disease that the doctors haven't been able to find, or they have got the wrong diagnosis. I haven't got an answer for that. I have no way of navigating that space. It is incredibly difficult.
So the factitious disorder is one of those controversial diagnoses, isn't it? Like chronic fatigue and functional blindness. And from what I can glean, there are two schools of thought. One school is the one you refer to, Martin, which is the patient knows that they're not sick, and they're faking it. They're putting it on for attention. The other school is they think they're actually blind, or they actually cannot see if they've got functional blindness, but there's no organic reason for it. And I think she's in that category where she truly believed that she had a terminal condition. It's just that there's no biological, no physiological evidence of that the doctors can find. It's
Well, in that case,
interesting
she was, according to the DSM criteria in the ICD one, she was misdiagnosed. It involves deception, necessarily involves deception. And there's a clear distinction between that and the kind of conversion disorders that you're talking about, where you get genuine physical symptoms because of your mental condition, or you misinterpret your conditions. So the puzzle remains, at least for me.
I was wondering how these cases intersect with the move towards a supported decision-making model. I was hearing on the radio this week, I think, somebody who was putting up, a lot more about the supported decision-making. And I guess one of my kind of questions, not knowing enough about this space, I will admit, is that I worry that a supported decision-making model would have simply added a lot more oomph to the patient's position and ideas, and would have made it even harder for a court or clinicians to do anything like what they think is in the best interest. In fact, I'm pretty sure the person I heard on the radio talking about all these resources she's created, or her organisation has created on supported decision-making, was very, very down on the notion of best interests, and saw supported decision-making as a way to get rid of best interests, or at least to significantly reduce a reliance on best interests. So I just wondered if anyone could comment on that intersection.
Just say totally, this is exactly the kind of case where that's under pressure. But Joan, Lucille, and maybe someone else might want to address that too.
I'll jump in really quickly. I think that the decision was wrong on the competence point, but I think it was quite a courageous decision on the best interest point. He really listened to her. He prioritized autonomy over the sanctity of life, although he said it wasn't inevitable that she would die. He gave her back her control and autonomy, and basically said, okay, the decision is now for you to choose. So that's really interesting. My only query is, given if we accept her diagnosis, was she free to make that choice, or was she under some kind of compulsion?
If I can just briefly comment about the difference. So there is an interface between the common law, if you like, best interests, and what supported decision making means now under the Convention on the Rights of Persons with Disabilities. And that is a huge issue to deal with in terms of any legal framework moving forward. I think we just have to be careful, because as an example, in this decision P, the judge has gone back to best interest cases which predate the Mental Capacity Act in England, because we're stuck in the common law of best interests. So, we can't write it out. Best interest is a bad word because it's loaded with medical paternalism. But the point is that the Mental Capacity Act in the UK has developed that further. And, there are arguments about how you could make that more into a supported decision-making model. So, we've actually jumped back 30 years with this judgment P, in the sense that the judge isn't looking at the current case law in and around best interest, because we are stuck with not having any statutory definition of what those, where decisions are made for other people, whatever term you use it. is in the law. So, yeah.
Thank you. So we've got a staff meeting scheduled now, so it's in my best interest to bring this very interesting discussion to close. I think we could talk about, I think we just started to tease issues out of this. There's a whole bunch to say. Thank you to everyone who attended and chipping in the discussion, and particular thanks to Lucille and Joe for helping set up such an interesting discussion.
Good to see you, people.
Oh,